My name is Shaun Hamilton, and I will be talking about the terms of service for Priceline.com and analyzing it and answering a few questions. So some of those questions are, is it a valid contract? Is their terms of service a valid contract? Are visitors bound to it, or do they have to click I agree? And if there is a dispute with Priceline, am I allowed to sue them? Why or why not? And what are the changes that I would make to this contract moving forward? So if we jump right in, we head over to Priceline.com and look at their legal action section. So under this section, arbitration and dispute resolution, we have a whole bunch of kind of legalese talking about, where they're governed, where this agreement is governed, and what kind of rules and regulations are specified for handling any type of dispute with them. Now, the first question is this a valid contract? So in order to address that question, let's first talk about what a valid contract is. Now, if we go over to our friends at rocketlawyer.com, they talk about the key elements of a contract. So in order for it to be a legally binding contract, there needs to be 4 elements: agreement, capacity, consideration, and intention. Now, if we look at agreement, an agreement happens when an offer is made by one party to another, and that offer is accepted. So I think this actually jumps right to the second question and say, are visitors bound to it, or should they have to click I agree? Well, in order for it to be a legally binding contract, both parties have to agree to it. So there has to be a place for me, the consumer on the other side of Priceline's contract, to actually agree to it. Now, if we go back to this contract, the legalese of this, and we look and we scroll down, is there any place for me to agree to it? There is not. So, under the kind of nuance of the question, is this a legally binding contract? I would have to say that this web page itself is not a legally binding contract. However, when we try and figure out how most businesses are binding their consumers to this type of contract, let's go over to our friends at the Electronic Frontier Foundation to find out, how do we bind users to the agreement and the terms of service? Now, most of them say that you have to click on the agree. So that answers the other question. Do we have to click on it? Yes, we actually have to agree for it to be a legally binding contract. So what this is saying, what our friends here at EFF.org are talking about, is that it has to be conspicuously present when and prior to any type of payment. So they have to present it to us in some type of way that allows us to agree to it, which is why whenever you go to purchase things online, you typically run into the checkbox that will prevent you from purchasing or making that checkout complete until you check the box that says you've agreed to their terms and service, their privacy policy, and all that type of thing. And at which point you have entered into this contract. Now, what are the other stipulations that make this a legally binding contract? Acceptance. So that's you have to make it acceptable. I have to accept to it, consent to this, entering into this legally binding contract. And capacity. So capacity is always talking about kind of, are we of appropriate age? Do we have the right mindset? And at this point, this is saying children under the age of 18 are not allowed to get into a contract and make it legally binding unless it's necessities for food and clothing or education, or the terms are fair and benefit the child. Now, I would argue that this particular idea for a contract doesn't really hold water, the unless part, right? So children under 18 are not allowed to enter into a legally binding contract with Priceline because Priceline is not selling necessities like food and clothing. It's not selling education. And the terms, I would argue, are probably not fair and benefit the child with that particular contract, and we'll get into why in a second. Now, consideration. Parties must exchange some value for the contract to be binding. Now, this is called consideration. There's got to be a point to the contract and an exchange of some kind. So this is where they put that clause right at the beginning, or they put the little checkbox to say, agree to this, because you're going to exchange money and they're going to give you your third-party plane tickets or third-party hotels and give you a deal. So that would be at the point of you agreeing to it and clicking to pay. They have met the requirement for consideration. Now, intention. Not all agreements between parties are contracts. It must be clear that the parties intend to enter into a legally binding contract. In the case of business agreements, the general assumption is that the parties intended to enter into a contract. So in the case of business agreements, this is a business agreement because you have agreed to purchase the services from their business and exchange money for it. So you have agreed to enter into this business arrangement. So you have, there is an intent. So they have met the intention, they have met consideration, they have met the capacity requirement, and as long as they provide you a place to actually click and accept, then at that point you have agreed into their valid contract. Now, I personally believe that visitors are not bound to this whatsoever, but let's kind of dive in, because if we were to have a dispute with Priceline, we need to understand how we would resolve that dispute. And right away in the legal action, it goes in and talks about arbitration, mandatory arbitration, how you're going to be able to kind of approach them with a problem. And they give you all types of kind of circumstances in which you need to do this or that, and but they are going to handle it all by arbitration. So let's try to understand what arbitration even is. So if we come over to the consumeradvocates.org website and we understand what arbitration is, it's an alternative method of resolving disputes in which two parties present their individual sides of a complaint to an arbitrator or panel of arbitrators. Now, the arbitrator decides the rules, they weigh the facts and arguments of both parties, and then they decide the dispute. Now, there's two different types of arbitration. There can be voluntary or forced. In this case, in business cases like this, where in order to purchase their services, they require you to enter into this arbitration clause. Now, so that's forced arbitration. Now, basically what they're saying is that you waive your right to sue them or to participate in class action lawsuits or to even appeal the decision of the arbitration. So the forced arbitration, it's mandatory, and the arbitrator's decision is binding, and the results are not public. So this is one of those situations in which, like, if we have a dispute with Priceline, you can't sue them if you have clicked agree and purchased through their website, because you have, by their terms of service, waived your right to sue them. You've waived your right to sue them. You've waived your right to any class action lawsuits, which they have spelled out in their mandatory arbitration clauses all through this. Now, they are governed by the laws of the state of Connecticut, and which comes into play because one of the key things about why businesses kind of claim they use arbitration is because they claim that it is cheaper to handle disputes rather than going into court. But as our friends over here at consumeradvocates.org will talk about, is that they ask the question, is arbitration cheaper? Because one of the alleged benefits is that it is. But it's frequently not true for the little guy, the consumer, or the employees. Because you actually have to pay exorbitant fees to even initiate the arbitration, and you have to pay for the costs of traveling to wherever the arbitration takes place. And so you end up, as the little guy, paying a lot of money in the end. And so one of the things that I found interesting about these clauses is that they basically set it up for the American Arbitration Association and the rules and procedures. So everything that you would do to file a claim against Priceline, you would have to handle through an arbitrator brought to you by the American Arbitration Association. Now, what I found really interesting, kind of digging into the specifics of this, was that the last clause here, if you or a third party do not choose to accept this binding arbitration provision, you or such third party must notify Priceline in writing by certified mail within 30 days of your purchase or before you begin to use the services purchased on this site, whichever date is sooner. Okay, so what that says is that if you were to, let's say, want to book a plane flight next week and you use Priceline, and by next week you haven't actually written out to them in certified mail and given it to them, by the time you go on that flight, you have waived your right to deny arbitration. Wow. So that, in the event that you needed to sue them, that's going to be a very, very difficult burden to overcome. Unless you know right away, and this is like a part of your plan and strategy for how you deal with online businesses, is to purchase something and immediately send them a certified letter saying, I deny the ability for arbitration. You will always waive your rights if they have these arbitration clauses, which a lot of businesses are going to, because it seems to be a benefit to businesses, but yet to me, it seems a detriment to the entire idea of our legal system as far as like getting your day in court. But one of the things that I found interesting was that the next little piece of this, if you decide to not accept the binding arbitration provision, you cannot continue to purchase services or products on Priceline unless they notify you otherwise. So that to me it's just an interesting provision in the sense that if you deny arbitration, if you just want to basically maintain your rights to have your day in court if they are to screw you over, and you have a legal right to file against them, then they just deny you the right to do business with them, which to me is just a very strong-handed way of protecting their business and saying like, well, fine, we're just not going to do any business with anybody that would ever have their rights to a day in court. Now, with that said, they do allow you the right to like kind of like a small claims court if you go through the arbitration proceedings and they don't work out. You can take them to court. However, you'll be going to court in the state of Connecticut, so you'll still have to pay a bunch of money. So like if the arbitration happened in California and you live in Texas, then you have to pay to go to California to do your arbitration and all of the costs associated with that. And then let's say it doesn't work out and you now have the ability to take them to small claims court and they're governed in the state of Connecticut. So now you got to fly all the way across the country to go to Connecticut and do all of that stuff and get in court. So it's basically, unless they really did something wrong in which you're trying to seek massive amounts of damages, I don't know that it's ever going to be worth it for the little guy to do that. So now, getting to what changes what I recommend, I think that it would be nice, at least from the user's perspective, to educate the user on this particular thing. Now, I know that it's been a practice to like hide all of these legal things under a term of service at the very bottom of a web page and the footer notes and everything like that. But like when you get to this page, one of the things that I think would be just helpful in reassuring the consumer that, that everything, like you're trying to maintain it on the up and up as much as possible, is to include something here that specifies that this particular thing is not a legally binding contract until you agree to the terms of service, and you actually like spelled that out in like non-legal ways. Like, I understand that they need to have this legal contract written as it is, but like having a place, like having another thing to like talk to you like a person, I think would be really beneficial in this type of forum, is to really communicate to your consumers and educate them in a way that doesn't make it seem like you're only here to protect your bottom line. You know, like, you can't be a business and say we're trying to provide the most value to our customers, you know, and have this like forward facing approach of marketing of saying like our customers are so important to us, while all of the back end stuff is really about protecting their business and not caring about the consumer. Because forced arbitration honestly is like, it's not really to protect the consumer, because it takes the ability for us as the base of consumers to fight any bad practices in the ways that our country is set up to fight those things. If we have to basically waive our rights to sue you, to have our day in court, we have to waive our right to kind of group together to stop you from doing any kinds of bad practices or harmful consumer things. I think that it would be a benefit to not only the business but to the consumer to, at this point, help educate them about what it is that these things represent. And, you know, so that when you have to click on it, you just understand a little bit more about, you know, the 4 key elements of signing into this legal contract, so that we're slowly educating us all about this process. It would just, I think it would just go, you know, not that, I mean, because nobody reads these things. That's another one of the issues, is that nobody really reads these things. And so if there was a way to like at least give people the cliff notes of the really important stuff, it would just, I think, speak to just a values thing, you know, like a values proposition for the company to say, hey, we really care about you and want you to know what it is you're getting into and know why we are doing this. I think that would be a very interesting addition. Now, the way that they have it structured, you know, I don't know that I would add or take away anything in particular. Again, I'm not a lawyer, so I don't really understand like everything about this, but I think that making it clear, like right away, that you have to be 18, like really getting the capacity aspect of this legal contract, especially when you're kind of starting this off with legal action, like this section is legal action, like being able to like specify that if you agree to this, we have met each one of the conditions for this legally binding contract. I think that'd be really critical. I think it'd be really good for them to spell out how, when you sign this a contract, this is how this is met. These are the requirements. These are the 4 key elements of a valid contract. And as long as you are 18 and are not misrepresenting yourself, everything is good to go, and you've signed this contract and you've waived all your other rights. I think that would be some of the changes that I would make. All right, so that sums up the video on my analysis of Priceline.com's terms of service. Thank you so much.